A kickoff.
That was a my moody kickoff. How did it go?
Yeah, thank you for that. I don't know why I'm a little like shell shocked by that, because we've had much more interesting musical choices. So thank you. Good morning, all. Welcome. It's good to see all of you, and thank you for joining us. We're going to get through our initial rundown, and then I'll turn it over to Trace. We will not do roll because we have fantastic people who can read the names, and will make sure to log that you are here. So I'm going to go ahead to the meeting minutes. And first, I'm going to do things in packets, trying to make this more efficient. And so I am going to start with, there was a set of general meeting minutes contained in your packet, and they're pretty basic. It just is information that launched us into our two subcommittees. Are there any members who have any changes to that full group set of meeting minutes? And I don't see anybody. And so if I could just have a motion and a second, please, to pass the full group meeting minutes for June 26th, please.
This is Michelle Dossi. I'll make that motion.
Good morning, Michelle, and thank you. And a second, please.
Carlos Castillo, second.
Thank you, Carlos. Is there anybody who opposes the passage of the general meeting minutes from June 26th?
I abstain. I wasn't here.
Great. Who said that?
This is Chris Mins.
Great. Thanks, Chris.
Same for Sam Carwin.
Thank you, Sam. All right. Seeing no opposition, I suppose, to the passage of these minutes, they will be approved. I'm going to move on to our two subcommittees now, and I'm starting with friends who are in the specialized occupation subcommittees. You know who you are. In your packet, you received both a set of meeting minutes and then the larger meeting recap from, again, that June 26th meeting. Can my members from the specialized occupation subcommittee tell me if you have any edits or changes to either the meeting minute document and or the meeting recap? And I see no hands raised from our friends in that subcommittee. All right, I'm going to go ahead and move these as a packet then, seeing no changes. Could I have a motion to approve both the meeting recap and the meeting minutes for the Specialized Occupations Committee?
Carlos Castillo, I motion to pass.
Thank you. Can we have a second? And Kathy, I think you're talking. Maybe you weren't talking. Can I get a second, please? From that committee.
Gina, I'll second.
Thank you, Gina. Are there any, is there any opposition to the approval of the meeting recap and the meeting minutes from that subcommittee? All right, those are approved and those will pass. Moving to the same process for the data subcommittee. Again, you have both meeting minutes and the meeting recap from that June 26th meeting. From my friends in that data subcommittee, are there any changes that need to be made to these documents? I'm not seeing any hands. Okay, if I could then have a motion and a second to pass this package, I'd appreciate it.
I move to accept the package. This is Ida Drury.
Thank you, Ida.
Alita Jenkins, I second.
Lisa, thank you. All right, seeing no opposition, we will go ahead and approve that packet for the data subcommittee, and thank you. Trace, that is it for my show.
Perfect. Thanks, Stephanie. Morning all. Excited to we got a 2-hour meeting today. Appreciate it. I was just thinking this is the best attendance I've seen at any of my July meetings. So kudos to you all. I know there's lots of vacations and whatnot, so appreciate folks being here. Just as a reminder of our remaining meetings for mandatory reporting. So today's 17th. We'll be back on the 24th. one in August, September, and then 2 in October. And then we'll be finalizing the report after that. As a reminder of our subcommittee meetings, these are the directives that each are discussing. And I was just looking at everyone. I think that 100% of the folks that are here have been at least to one of the meetings so far for these subcommittee meetings. So I won't go too far into detail here. And this is just a reminder for who's in which subcommittee, because it's a 2-hour meeting. I just wanted to get us quickly into those meetings. So if you were in the specialized occupation subcommittee with me, we're going to be hopping to the other link today. And folks in the data subcommittee are going to be sticking in this group. So you'll see in a moment a link in the chat. Is there anybody that doesn't see their name reflected on either of these subcommittees? Just come off mute if so.
Hey, this is Sam. I don't think I see me.
Okay, Sam. Would love to see you in the specialized occupation if you're cool with that.
Cool, yeah.
That would be, I think that'd be a good
That
spot.
was my understanding.
Okay, great. So you'll be jumping on the link and I'll make sure that your name's reflected on here moving forward. All right, y'all. So with that, if you are with me, the link will drop in just a second and we'll go over and then we'll come back, Doris, at the 45 to 50, depending on if we need a couple extra minutes. Just for public comment. Appreciate folks making an effort to come back. Ensure we provide public comment, and then we'll be out of here by 10 o'clock Mountain Time today. All right. I'll see folks over in just a moment for my group.
All right, Trace, I'm just getting the link.
You're good. You're good.
Here is the subcommittee link.
If you were speaking, Trace, it looks like you're on mute.
For those of you who are joining from the public, you can just pick a subcommittee that you want to listen in on. So feel free to stay in the main room where we'll be talking about data and information. And then in the breakout group that folks are joining now, you can they'll be talking about specialized occupations.
Brian or Doris, real quick. Sorry, my Zoom keeps glitching out. Can someone repaste the link for me to jump over? There we go. All right. Thanks, y'all.
Awesome. I see Trace is moved over. Is there anyone else who is wanting to join the other subcommittee that's having trouble? All right, seeing and hearing none, we'll go ahead and dive in. It's good to see everyone. I'm sorry I missed the June meeting, so it feels like 5 ever since I saw everyone. Happy summer. I hope you're finding time to rest and restore. I thought before we dove into today's topic that we would just sort of bring us back from the prior conversation, making a little bit of a connection. Brian is going to provide just a high-level overview, and we do have our participants or guests from CDHS who are joining our conversation today. So we'll have a chance to hear from them on current practices and guiding rules and policies. And then before we actually dive in and have what I hope is a robust and engaging conversation. So I'm going to hand the mic over to Brian to just share a little bit of a recap of last month's meeting before we talk about data and information sharing around reporting to particular audiences.
Yeah, thanks. So I can just briefly go over our discussion. For those who are here, there's going to be a little bit of overlap in the content area between last discussion and this. In our last meeting, we talked about the directive that's built around analyzing the personal information of a child that's collected as part of a report of child abuse and neglect. And we had this great panel of folks from CDHS who were able to help us have a more informed discussion about that topic. And these folks are kind enough to come back and join our conversation today. So I can just give a real brief intro there. So Jessica Starr, who I see is already on the call, thank you, is the Research Analysis and Data Unit Manager at the Division of Child Welfare. April Jenkins is the Child Protection and Prevention Services Unit Manager at the Division of Child Welfare. And then JP Sleeger, who I believe might be joining a little bit in the future, is the Trails product manager. So was able to speak about the software and those implications of data collection attempts. So broadly speaking, we spoke about the personal information that's collected as part of reports of child abuse or neglect. And that included just kind of a recap of information on what kind of demographic data is collected, some questions around consistency and differences between the legacy trails and mod trails. JP was kind enough to walk us through and share screen on what's capable for the data collection in the Trails mod. We talked about some other recently enacted legislation that talks about reporting requirements tied to breaking down disaggregated data and how that might interact with the current requirements for collecting the data and how those two might be brought into greater coordination. And yeah, just had a general conversation about some questions around needs for consistency and having consistent data collection that includes some more emerging areas of particular interest, like having specified information on how the information was collected, if that was a web platform report like we have possible in Weld County. And then we also had a good conversation about some of the potential challenges behind gathering information like on race and ethnicity in particular, if that relies on assumptions being made by some third party, like looking at last name or just guesses based on physical appearance, versus the better validity that comes with having self-identification as part of that. So yeah, we had quite a lot to talk about. Does that bring us up to a jump off point for today, Doris?
Awesome. Yes, it does. Thank you so much, Brian. It felt wonky since I wasn't at the meeting, just sort of playing back what was in the meeting recap and the minutes. So I thought it would be helpful to have Brian share out a little bit about the discussion at a high level for those of you who were not able to attend. And also for those of you who were, there have been many days in between. So just to get us back to our prior conversation. Today, we're actually going to be focused on interagency, and I'm actually going to share a screen because it has the directive in here, a process for inter and intra-agency communications, confirming receipt of reports, and in some circumstances, sharing the outcome of reports with certain mandated reporters. And I have a few guiding questions that I want to talk through and really want to hear from, sort of jump off the conversation with our folks from CDHS and DCW. I'm going to do a slideshow just to kick us off. And then before we wrap up today, I do want to get to folks thinking around specific recommendations within this directive, and have a note catcher that we'll make some space for folks to just provide some individual inputs and then have a broader discussion. So I hope we'll have a chance to do that as well. So again, the directive is focused on analyzing the process for inter and intra-agency communications, confirming receipt of reports, and in some circumstances, sharing the outcome of reports with certain mandatory reporters. And you may recall that this conversation specifically around sharing information about reports being made, we talked a little bit about when we were talking about multiple reporters of like the same set of facts or circumstances for child and family. So there is a thread that runs through our prior conversations that connects back to this specific focus around what information is allowed to be shared between agencies, not just, where there might be duplicate reporting, but also where, we're thinking holistically about serving kids and families. Information sharing might be helpful in again, meeting the needs of kids and families. So I wanted to start with this question around what information can currently by rule and policy be shared with outside agencies. So a report comes in and want to hear from, again, I'm going to stop screen share just so that, and I'll put the question in the chat so we can look at each other. But what information is currently allowed to be shared outside of CDHS or outside of child welfare at the county or state level? And we'll use that as a jumping off point. April, I see your hand raised. You're muted, dear.
I hit the button and it didn't work. So now they're sorry about that. Hi, everybody. I'm April Jenkins, Child Protection and Prevention Manager with DCW. And so I can answer some of this question too. So confidentiality, as you know, is very important. And working with outside agencies is also very important. So a lot of our outside agencies, so let's use law enforcement as an example, or agencies such as maybe our child advocacy centers. I'm just thinking of a few examples. We, a lot of times in those situations, have memorandums of understanding, so MOUs in place with those agencies so we can share information. Another example is something I've worked with a lot over the years is military bases, is having MOUs with our family advocacy centers on base so that we can share information with them. Outside of that, we do require releases of information and so for instance, if a family is working with a therapist, just as an example, then we would require a release of information from the family member. Sometimes we need releases on both sides. So the therapist would need the family to sign a release, and then we would have to sign a release. So there's sometimes can get a little bit complicated, but that's how we start. And so what information can be shared is it depends on the situation. So if I'm working directly with law enforcement during an assessment where law enforcement is also involved in the situation, again, we're in assessment mode, I'm going to be sharing information with law enforcement if we have that, assuming that we have that cooperative agreement in place. Now, once we get into more of the case or the permanency case, that information sharing does slow down, if not stop, because a lot of times law enforcement's done by then as well. But that's sort of where we start. And again, depends on the situation and what kind of releases of information or cooperative agreements I have in place. Another really good example is when I worked with El Paso County years ago, we created a special MOU with public health. So that was so that we could work directly with them on families that we were concerned about that may needed their services, and then it was vice versa. So we had we put in a lot of effort and time into working out some agreements so that we could share information with each other. If there was a family, let's say a mom that was pregnant, and we had allegations of using substances, it may not have met criteria for us to assign that, but based on our cooperative agreement that we had with public health, they could see that report, so that they could do some outreach and offer some services to families. The agreement was they would reach out to the reporter and not directly to the family member. So the reporter was giving the information for services or support for that family member that may be using in that case. So that was just an example. So I'll stop there because that was a lot. But
I love that example that you provided with El Paso County and the agreement with the public health department. I think as we think about, and I do have a question coming, but as we think about specifically the front end opportunity, so a family gets reported on or a family has needs that really don't suggest child abuse and neglect, what might be some ways of providing services and supports to that family without the trauma associated with a formal investigation and everything that comes along with that. And so my question, and April, maybe you can answer this, maybe Yolanda can answer this, but is whether, well, two things. One, whether or not you know if whether that agreement is still in place in El Paso County. And two, if you know of other counties that have similar kinds of arrangements, specifically with public health or other entities that could provide for some of the services and needs that families might have, again, that don't constitute child abuse or neglect.
That's a good question. I don't know about the El Paso one. I've been gone over a year now, so I'm not positive if they still have that in place. One thing I do know they have in place is this is another example is contracts with other agencies that do provide similar services. So those are in existence. So Peak Vista Community Health Center, I know those are still in place, and they function very similarly than public health does. And I don't know about other counties. I wouldn't want to speak for certain unless I knew and asked. So I would, I wouldn't want to assume.
For those counties that have contracts, do you know if those contracts enable information sharing of a report coming in, again, where there might not be formal child welfare involvement, but a mechanism for outreaching to either the reporter or the family?
Yeah, so there is confidentiality written into some of these contracts. The one with Peak Vista, that was a very bad example because they are actually only going out if we assign something, and they're actually accompanying caseworkers to go out and provide services to families. But we also have what we call our prevention services, our program area 3 in child welfare. Program area 3 provides prevention services to families. And one way a family could access those services is maybe making a self-referral, or if a referral comes in and it does not meet criteria for assignment, then it could get screened out or not assigned, and we could outreach to that family to offer them services. And without them being involved in child welfare, they can still receive services, or not having an open assessment. Another thing that we're working on in child welfare too is updating our prevention plan, and our prevention plan creates a community pathways option. And that community pathways option also allows for families upstream that are not involved in child welfare. They can receive services before they even their names even listed in our system. They can still receive services. So I know that's going on a tangent and kind of off topic a little bit, but there's just so many ways families can receive services without having any child welfare involvement. But with regards to the contracts that I know of, those are families that are involved. Now, some of our core services are they can be offered to families that are not necessarily receiving an investigation or assessment. They can get it through multiple ways.
Thank you. Yeah, and I was thinking about that specific. I mean, I think the prevention programming and community pathways, I think that is an important part of this conversation, because we started out now over a year ago, really learning about, one of the primary drivers for mandated reports is that, we know a family needs services. We're not sure how to, get them connected to services otherwise, may not even think this is child abuse or neglect. And so they make a report. And so if there are ways for families to get connected outside of a formal report to the hotline, I do think that is within scope of the conversation here. I want to pause there and see if other folks have any kind of related questions on, what can be shared and with whom with respect to reports made to the hotline. Michelle?
Yeah, I mean, I think we should talk about this. And I'm hoping maybe Yolanda can help me with this. I mean, I think this is something that counties have been challenged with about what information can be shared with the community when we are not involved, including sharing information back with a reporting party, mandated or not, about the county's prior involvement with a family or information that might help a community partner provide preventative level services. I certainly know when running Arapahoe's prevention program, that was a long-standing struggle about how we could share information with reporting parties, how we could make referrals for preventative level services without confirming or identifying that a report had been made and what the status of that report was, whether it was accepted for assessment or not. And I don't think that there's clarity specifically in the law about that. And I understand there's a balance between protecting the family's rights, but also maybe not necessarily unnecessarily absorbing a family into the child welfare system or not, because we could not share information openly and transparently. Previously, before we started doing our preventative services in-house in Arapahoe County, we did contract out with other agencies to provide those services. And we felt that there were challenges that we couldn't share specificity. We couldn't share the actual report. We could only say that we had information that the family might be struggling with homelessness, for example, and then having that community partner reach out to the family, but then not having the total information when they were trying to work with the family, confusing the family about, well, why is the department not calling me versus why is this other, we contracted out with our public health agency. And so I don't think that there's clarity in the law. That's my number one statement around what can be shared and when. And I think one of the challenges that we have had in the child welfare system here in Colorado is the inability to share information when kids needed support. So one of the things that we had really wanted to get off the ground in Arapahoe and struggled to get off the ground was something called Handle with Care, where we could notify, like, let's say that, police had been to the house the night before for a family. There were no criminal charges. Maybe they responded to something, traumatic for a family, but the child welfare system wasn't involved. How could communication be made to school districts the next morning to say, hey, keep an eye on this kiddo, get them some help, get them some support, or give them some grace if they're struggling because they didn't get a full night of sleep? Like, how do we have that open and transparent communication to say, please support a family, they're going through something difficult, without actually sharing what those challenging details were, or what the trauma was, or something like that? So I think, that's another thing that we really wanted to be able to do, is to be able to have that open line of communication, but struggled with that confidentiality piece.
Awesome. Thank you, Michelle. Jessica, I actually was going to call on you. I was trying to go back through my email because I was like, I feel like Jessica shared out some of the laws and regulations around information sharing and confidentiality. And I know that you're popping some resources in the chat. If you could come off mute, I think specifically in response to some of the challenges that Michelle noted, I think that would be really helpful.
Yeah, absolutely. And I'm in the process of putting the second one that I found in chat, because I went through volume 7 to really take a look to see what was explicitly listed, because I feel like the hard part is sometimes trying to interpret what's been explicitly listed and then what is not explicitly listed. So where that gray area may or may not exist. So the links that I have put in, I have one specifically for CFR, or color code 191307, which really governs kind of who has access to child welfare records. And then I've also put in a link to chat to what confidential information is protected and what the procedures for release of confidential information are pertaining to child welfare records.
Are there,
So,
is there a Cliff's Notes version that you can share?
yes, I am. Let me just navigate it back.
And then I know we have some resident lawyers in the group. While you're doing that, I want to, Michelle, I see your hand raised.
Thanks. It's sort of a continuation on what Michelle was talking about. And I do know, I am a lawyer, and I do know there are some broad-based, there are some flexibilities and I think requirements even for MOUs around information sharing with school districts, but I don't think it's clear, and it's been a while since I've looked at them, but we see in implementation real problems getting information both around support, as Michelle was alluding to, but then, you know, when we make a report to the hotline and around an employee suspected of abuse and don't hear back for days, weeks, or months. So some clarification around whether the report was received, whether they were unfounded. And remember, it's not just human services that we're talking about, it's law enforcement. Because I believe those complaints are forwarded to law enforcement if it's outside of the family. So there's the piece around employees and needing that information and clarification around that. Or Jessica, if it's already there, great, show me where, and how can we elevate it as part of this process? And then also changes in parenting rights as a result of these instances. We need to know at the schools if a parent no longer has if there's a restraining order or whatever the proper language is in place while these proceedings are going on, when it's completed, and then finally a whole myriad of issues around when kids are placed in foster care and how we know about that, those kind of things.
Yeah, Michelle, I'm wondering then if maybe our best one to start off with is the 191307 for the dependency neglect records. If we start at point 2, it goes into records and reports access for certain persons and agencies. Point A on there is the law enforcement agency should have access to records and reports, district attorney, coroner, or county or district Department of Human and Social Services investigating a report. Let me find, I know that you had spoken about employment, and I think when I was browsing through this, I believe I had seen that listed in here. Boo, 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 boo. Let me look. Let's see, I can see that the State Department of Human Services is investigating an applicant for employee or volunteer position.
I think that might be a different circumstance, right?
Yeah. And I think that one of the challenges is, you know, so every state has confidentiality laws around sharing of information related to child abuse and neglect, allegations and substantiations. I think the question becomes, you know, as a practical matter, you know, one, clarifying what that actually means, and in like regular people terms, you know, because a lot of the county staff they're not lawyers. And 2, providing some guidance around what mechanisms could be put in place in those instances where, bless you, Donna, where information sharing would be really helpful for the family. And so, you know, is it an MOU with certain entities? And if so, is there a template for MOUs? And I feel like Yolanda, you shared out when we were had some prep conversation in advance of the task force meeting, you know, templates that could be used for counties, again, to provide some a bit of a toolkit, if you will, to aid counties in implementing practices that could facilitate some information sharing with specified entities for the support of kids and families that still meets the legal requirement. So I said a lot there, but I do think that that there is an opportunity to maybe put forth some recommendations to make it clearer in regular people conversational terms when and how they can share information, and providing some specific tools for counties to do so to support families.
Doris, I
I'm
would
so
just
sorry to-
clarify just real quick that we already have MOU requirements in the law, and for a long time, if not still, the AG's office had a template, but really all the template was a reiteration of legislation and rule. And it, I mean, even like I'm going through it and it doesn't make any sense. So if they're going to do something, I don't know that we need a new MOU requirement. We lawyers are a real pain in the butt, and those
100%.
move in the way that we would like. So just some plain language clarification would almost be really helpful. And Jessica, I know that's what you're putting forward there, so that we understand what it currently looks like. And then do we need to make any changes or recommend any changes, and also make sure that that's available to the public at large.
Yeah, and I'm curious whether or not the El Paso MOU with the public health department uses that used that AG template, or something else, in the extent to which it includes some of that plain language that you're talking about. So I would be curious to see if
I think the template is
the same
specific
template.
to schools, law enforcement, and DHS, but I could be completely wrong about that.
Okay.
I'm happy to try and find that again and shoot it out to Trace or whoever.
That would be fantastic. Thank you, Michelle. I want
And
to
I'm
go to
so sorry
April.
to jump in.
No, go ahead, Adriana.
My day-to-day and in my wheelhouse, I actually just drafted an MOU to speak to this as well. So I'm happy to share all the templates. To Michelle's point, love the AG's office. Don't love that MOU template. Do not find it helpful at all. So, I think it should be shared with the group. So if someone else has a different opinion, but really, and thank you, Jessica, for pointing out to the statute and to the regs, it's not clear. Literally in my day-to-day, it is a constant review with caseworkers coming over here and saying, can I share this? Can I talk about that? There is no clarity. And I know at least from my end, we have made, and I have seen this giant push about getting, because of course we want to keep things confidential. That's absolutely fair and appropriate, but there's a lot of things that can be achieved if we had a little bit more leniency and more grace. And what I've discovered in my practice is that about all 64 counties have a different approach as to what's appropriate to share, when, where, and how. There is no clarity. There is no standard procedure. Everyone is just trying to do the best in basically trying to respect that privacy and achieve what needs to be done. And so it would just be beautiful, generally speaking, outside of this group and within this group. But a lot of the easiest way that I have found is to just have a lot of MOUs in place. So I know for Delta County, we absolutely have active MOUs with law enforcement, school districts, hospitals. Like we are constantly trying to find ways in which to connect and establish relationships and information sharing with these entities.
Thank you, Adriana. April, and then we'll come to Dawn. And then Jessica, you had your hand up and then took it down.
So I'll go ahead. So I just real quick, there is an MOU MOU template that we use. This MOU template was created through a task force or task group that was used to create an MOU for between law enforcement, including a separate one for state patrol. That MOU has been out there for quite a while. It's just a template, and we've made it very clear. This is just a working document that you as a community can adjust as needed to fit the needs of your community and whatever you come up with between you and your law enforcement agency. We actually have that template pulled out right now. It's still out there. And why we pulled it back just a tiny bit was to make some slight revisions to it, because in our Child Fatality Review Team Steering Committee, we realized there's some areas where we really need a little bit more clarity in that MOU. The MOU, I think, is a very good MOU. It is very, very basic in the sense that it lists out specifics of when law enforcement and DHS, for instance, would speak to one another, or when law enforcement would call in a report to child welfare. So pretty robust basic template, in my opinion. And again, we have it pulled out because we're adding a little bit of language. For example, some of the language we're adding in there is about sharing of records between law enforcement and DHS. Because what we have heard over time is that law enforcement sometimes does not want to share with DHS because they don't think we share really nice with them. So I'll be very clear, and that's kind of in a nutshell, a little bit what it's about. It's about sharing nicely with one another. Not all communities are willing to sign MOUs. Not all law enforcement agencies are willing to sign MOUs with DHS. I'd say about 50-50 at the moment. And it may be a little bit on either side, but that's sort of where we're sitting. So with that recommendation to put in some language about equal and some reciprocal sharing of information between of records, then we may get somewhere with having some different conversations at tables in communities between law enforcement agencies and DHS sharing information. So I just wanted to share that out there. We have a lot of that information that Jessica shared that from that 19-1307. So a lot of that information is in there as well. Other statutes quoted, but it's also list out some pretty basic lists about, hey, DHS is going to call law enforcement if they go to a home and maybe the children were witness to a domestic violence incident. Law enforcement is going to call DHS if there is a fatality or if there is some other type of incident where a child was involved. So it's pretty basic, like I said, but pretty broad. I think a decent template. So just wanted to put that out there. That is there. That is something that is being worked on in every community across the state, and we ask that they be updated every so many years. I think it's 5-6 years. That they are updated and resent back to us. And we're in the process now of counties needing to send those to us so that we have them on record. So just wanted to throw that out there. And then I wanted to make a point to something Michelle said earlier that really stuck with me, because I understand the worry sometimes we have for families, because sometimes maybe something doesn't really meet our criteria for assignment, but we're still worried about something, and we would like the school to maybe know that we're worried about something, for instance, and how we are limited in those capacities because of confidentiality. So I wanted to just acknowledge that.
Thank you, April. And I saw that Crystal put it in the chat that I think is important to name, like this question around whether there could be a common template similar to the one for law enforcement that speaks to other primary entities with which information sharing, specifically around reports made if an investigation is currently open or assessment is currently open, sort of like some specific parameters, but for entities beyond law enforcement. Sounds like there might be an interest and desire in that. And I think that two things. One point about uptake, right? Like, with the law enforcement one, it looks like, roughly half of the jurisdictions. I think, it might be interesting to see. You said that you asked them to send those back so that you can capture, which counties are actually using them. I think that might be helpful. But the other piece is that Like, it can't be so legalese that it's ultimately useless. And I'm wondering how different this it sounds like it might be substantively different, this MOU template is from the one that the AG's office provided that was ultimately unhelpful. Dawn? You're muted. We still can't get it together.
There we go. Oh my gosh.
There we go. No problem.
April, I want to thank you for clarifying that there aren't MOUs in 50% of the cases with law enforcement. I represent childcare programs, and sometimes in a situation, it'll be DHS is there and the sheriff's department or the police department is there, and it feels very, very, very intense and overly intense for this situation. And so that gives me some reasoning to go back to the program and be like, there may be this kind of thing going on. This is outside of the MOUs, so it may be a different rabbit trail, but I have talked to at least two people this year that had a finding against them personally, directors, that sort of thing, when they weren't relevant in the situation so much. It's and for them, they had to step out of their role for months until they got the report. And when the finding was founded against them, they went through appeal processes and all of this, and eventually it's overturned. But by the time that happens, their professional standing is completely undermined, and we end up losing them out of the industry. I mean, they are devastated, and some of them will go through the appeal process. Others are like, I'm done. I can't even deal with it anymore and won't. I know of another case where someone was like, I just can't. I'll just do something different. I don't know. Some of them don't know what their appeal rights are. Like, I just want to emphasize that has to be very, very clear throughout the process. And we have to understand that their professional livelihood is at stake the entire time that it takes for this process to happen. And I don't know that we can do anything to shorten those timelines, but something has to help these people. Our industry is suffering enough. To have this extra dynamic that sweeps people away is just very infuriating.
Thank you, Dawn. Yolanda, I saw your hand come up.
Hi, yes, everyone. I was thinking just kind of back earlier to Michelle's question and then just tying in to what you were just sharing, Dawn, about like when there's an employee that may be founded for an alleged abuse or neglect situation, and if the agency then receives notification. In my experience, the county does not report that finding to like the school or the daycare center or wherever. They usually, what I've seen is that agencies will have a personnel requirement that if you are, you know, if there's some kind of situation that you find yourself in, like if there's a criminal investigation or some type of, you know, traffic ticket or something like that, that you have to report that to human resources if it would have any impact on your professional standing with that agency. So I'm not sure for like Dawn and Michelle, how that really plays out with the agent, like schools or daycare centers or other agencies where a founded finding may impact their employment. I also know other agencies do annual background checks to see if they can catch anything that may not have been reported. I know that when I worked at Denver County, like human resources reached out to me before I even got the chance to tell them I had a traffic citation that I received. And I was like, how'd you already know that? Right. So they're a lot of times checking background. So I just wanted to share that as just like not right or wrong, good or bad, just that generally is my experience that founded findings are not directly reported from the county to the agency directly themselves. And I think the other thing I just wanted to say regarding the conversation about law enforcement and the MOUs and the different relationships, in my experience in hearing from counties as well, a lot of that is relational about how much or how willing folks are to share information. And what I mean by that is that there are some law enforcement jurisdictions that have different units. And so, for example, in a county where there's a child abuse type of unit with detectives, they're more commonly working with the child welfare caseworkers at that given county, right? So their relationships often are the foundation of information sharing within reasonable confidentiality. What I saw just in my experience at Denver County is that when there were situations that crossed over with other units like homicide or traffic or things like that, there weren't those relationships with those detectives. And so there was less of a willingness, I think, agency to agency to be cooperative in those situations because there was no foundation of a relationship where you're seeing those detectives, every week, if not, every month. And so that was just my experience, as well as that different units investigating just impacted how willing both agencies were in sharing information where there might be a joint, or there might be a criminal investigation while there's also a child welfare assessment going on. So just want to share that as perspective. Thank you.
Thank you, Yolanda. Dawn, I don't know if you had a follow-up, and then I want to come to Michelle's question in the chat. So we'll start with you, Donna. Dawn, why did I call you Donna? Dawn, sorry.
That's okay. So it is interesting in a child care center, when it's the director, it puts them out for months on end while they're waiting for reports and findings and stuff, because they cannot physically be in the building while the investigation is taking place. And so they're trying to run their program and maintain safety in their program from some offsite location because they can't be there when kids are there, right? So that initial part is very devastating to a program. If it's a teacher, 9 times out of 10, they just fire the teacher because they're like, I can't have this potential on us. Like so they release the teacher because of the allegation once that investigation starts, because that squares them with the Department of Early Childhood. That teacher then turns around and goes and finds another job very quickly before the finding is actually complete. And so they can run a trails at the new location and they're clean and clear with no issues, right? And so they can get hired on at the new facility, and they don't ever know until they have to do a trails way later that there's actually a positive finding for child abuse on that staff member, which puts that new program at risk as well. So just some nuances in our industry that complicate things here.
Thank you, Dawn. And then Michelle put a question in the chat, Yolanda, about whether there should be a change or different impact if the employer makes the report.
Yeah, I think that would need a couple of things. One is, I think different agencies have different personnel related matters. So like what Dawn was describing, the county department doesn't require a person to go out on administrative leave while there's an open assessment. That's the agency, like the agency's requirement, right? That they may put somebody on temporary administrative leave in those situations. And so I think the question about whether, should there be more information shared because an employer is making a report between the county than in that employer, I would want to get like some legal consultation around that, because there's probably some due process. Because again, like, unless, I guess I get it, with the employer making the report and then their personnel requires them to put the person out on administrative leave. And since an assessment can take up to 60 days and sometimes a little bit longer, that is a long time to potentially be out on leave while things are getting sorted out as far as the assessment goes, and if there's any other subsequent investigations as part of that. So that's a long-winded answer to say I'm not sure what the due process considerations in that would be.
Thank you, Yolanda. I want to come back to a question that Michelle D put in the chat around specified mandated reporters and sort of like that particular class. Just want to Michelle, invite you to share a little bit about what you're thinking, or as we as we think about potential recommendations around information sharing, thinking about the different classifications of mandated reporters that exist, and whether and to what extent there should be some nuance around information sharing that depends on the classification of mandated reporter.
Well, I've heard from this task force a gajillion times over the last 18 or so months that there's concern frequently from reporting parties that they don't know what happens to the reports that they make. They don't know what the department is doing or not doing. They don't understand all of those things. And there are laws that prohibit us from sharing information with the exception of specified mandatory reporters. And those are folks who are mandated, who have an ongoing relationship with the child and a need to know the information in order to keep the child safe. And the county is required to, I'm going to use this word loosely, certify that that's true, that they're specified. And then that reporting party, that classification of reporting party has up to 90 days after the referral is made to ask for additional information about what steps the county took to achieve safety. And so, first of all, I think it's a very difficult process for counties to manage, to gather that information and then make sure that that information gets reported back out to that classification of reporting parties. But I think it's often not known, or it's misunderstood by specified mandatory reporters. So just for those of you who might not understand what I'm saying, for, example, an emergency room doctor would not be someone who has an ongoing relationship with the child and a need to know information in order to keep a child safe, but a teacher might. And again, they have to, in asking to be a specified mandatory reporter to get additional information, again, they have to demonstrate that them receiving that information will help keep the child safe, that they will use that to help keep the child safe. What we found in Arapahoe is that a lot of specified mandatory reporters don't want to or don't take those steps to get that information. And I think it's just the way that the statute is written. I think and the rules around it are very confusing and hard to get information. The other thing I would say to you again is that confidentiality is good and it's bad, right? I don't want folks to have whatever information they want to have about families because they think they need to know or they have an interest in knowing. But I also think when information is not shared, and I think caseworkers are challenged with, they're trained so heavily during their academy trainings and onward in their recertification every year that they're obligated to keep information confidential to the point that it ends up harming families because they won't cross-share information. They use that as a reason not to communicate with community partners, so then they don't get the full balance of information as a part of their assessments. And it ends up keeping families unsafe or harming them in some way, shape, or form and getting the services that they need because they don't feel like they can communicate. So
yeah,
I don't think that the laws are well structured. I think we've talked about that. They're confusing. Confidentiality ends up getting weaponized against reporting parties, against families. And so there's, I think, a lot of work that we need to do. And I think it's a big task to really, I think that's a whole nother task force, is the confidentiality pieces, the cross-reporting pieces, again, sharing information with law enforcement, all of those things around the statute. The statute is just absolutely not clear, and it's in multiple places in the state.
Thank you. I want to come back to the specified mandatory reporters. So from what I heard you say, is that there's not an automatic classification that comes with a particular role that makes somebody a specified mandatory reporter. They have to request that.
Yeah, so we identify at the time of the call if they're a mandated reporter, and then we ask if they're a specified mandatory reporter. I can only speak about Arapahoe's process, but we would send them something in writing that says this is what a specified mandatory reporter is, and they fill out a form and then send the information back to us. And then we, again, use that term loosely, certify and say, yes, that's accurate. You are specified, and now you're entitled to this set of information within that 90 days of making the referral. So one teacher to another might not be, it's not based on just specific job titles, right? So, a teacher who subs for, a classroom might not have an ongoing relationship with the child. So the teacher as a substitute doesn't qualify, but maybe the child's regular full-time teacher does. But it's not just having an ongoing relationship with the child. It's about that and how they're going to use that information to keep the child safe.
Thank you, Michelle. And I have, oh, sorry, go ahead, Yolanda.
No, I was just going to clarify that a little bit further, because I think and JP can correct me if I'm wrong, we have relationship and we have role in gathering information, because those two things together help us determine mandatory reporter, specified mandatory reporter, right? So role can be like teacher, relationship can be I'm their primary classroom teacher, or I'm their, primary care physician. So just wanting to be able to, because as Michelle already stated. So I just wanted to clarify that a little bit more, how we gather that information into trails, role and relationship.
Thank you, Yolanda. And then Crystal had a question in the chat that I just wanted to name and follow up to what you shared, Yolanda, about relationship. Is the relationship question related to the child, or is it also related to the relationship or not with the family?
It's with the child.
Yeah, for specified mandatory reporter, it is with the child.
Okay. That's what I thought you were saying, but I wanted to make sure that I named the clarification. And I love that you named JP, who joined a little bit late. We know he was going to be late. Welcome, JP. I did have a question about trails and, specifically around the specified mandatory reporter. Well, I have two questions, one for April and one for you, JP. So I'll come back to the question for April. But in trails, when someone is then subsequently identified as a specified mandatory reporter, is that reflected in trails in some way? Is there like a checkbox or something that denotes that someone who made a report is a specified mandatory reporter?
Yolanda or April, feel free to fill in any gaps that I might miss here. But yes, it's a pick list, Doris, of I think all of the different reporter types that are outlined in rule. And I think that if a hotline worker selects specified mandatory reporter role that's outlined in rule, then they will generate in the mandatory reporter queue after that hotline record has been created. But those designations are a drop-down list that workers select from each time they enter the mandatory reporter information.
There's like there's own tab. So you're picking the reporter role, and then there's a separate tab for like I think I'll have to look at it specifically for the specified mandatory reporter, where trails will create a template letter, right? That then can be sent or emailed to if we're identifying. So there is some subjectivity in that, because you go from reporter role, that's like a pick list, like JP mentioned, to the tab about specified mandatory reporters and whether you're going to send them a letter or not. That part of it is like a manual process that then the system creates the letter for. So not everybody would be due a letter, as Michelle Dossi already has said. So if I, as the hotline call taker, say this is a teacher, then I have to go over to this other place where I would create the letter that would go to them. It's already outlined in the Code of Colorado regulations, what information in that template letter they're able to know whether their report was accepted for assessment or not. And if it was accepted for assessment, which is the caseworker that would be assigned to that, and then whether it resulted in services being offered to the family.
Thank you. So and maybe this is a question for April, when a worker takes the report, so a hotline worker takes the intake report, do they, once the reporter type is identified, will they automatically be prompted to then go through the sequence of questions to determine the reporter relationship in determining whether or not that qualifies them then as a specified mandatory reporter?
I think the process is different in each county about how that's done. I would tell you that we ask if they believe that they're specified, and then we send them an email with information and a form they have to fill out and send back. And then once we verify all of that information, then they're classified by Arapahoe as a specified mandatory reporter, and then subject to be able to get additional information. But I don't think it's consistent across all the counties, and April and Yolanda can correct me if I'm wrong.
Thanks, Michelle. No, and that's right. It is different. I mean, if I were to call Arapahoe today versus Larimer County, I might get a different, set of questions. I mean, we do have enhanced screening questions, but that doesn't necessarily get to that, some of those. So yes, that's right. It's not all that consistent.
Okay, so then it sounds like then there is an opportunity, but that specified reporter classification, sort of by design, is a classification that enables access to more information for that reporter. In general, though, well, we know there's some inconsistency in that determination, and I got to tell you, based on prior conversations we've had about mandatory reporters, and what I know about mandatory reporters is there are some folks that likely would be classified as a specified reporter, but because of the extra steps involved, likely won't complete all that additional paperwork because they barely had enough time to make the report in the first place. Which then brings us back to this question that to me around, whether and to what extent, there could or should be some additional recommendations specifically around reporters and reporter types that might be, and kind of how you would do this, I don't know, but sort of making more information available and under some specific set of requirements. And so I don't even know if that was very clear, but it just sounds like the default position is virtually no information sharing back to mandatory reporters without going through like some specific process. And I just wonder if there's an interest in providing some guidance or clarification around information sharing back to some mandatory reporters, and then if so, under what circumstances and who would those mandatory reporters be?
I think this is a both and for me, because again, there are reporting parties out there who weaponize information that they get from the department against families, and protecting families' rights to a privacy of information. Like, I don't know that, my child's pediatrician needs to know every ounce of my child welfare history and to the extent of my involvement and findings and all of that. But then on some occasions as a child welfare employee, I have felt like if the reporting party could understand A, B, and C, they might treat the family different, offer different services, or support the family differently. So I think that the information that we give as a specified mandatory reporter is serious information that holds responsibility and weight, and that not everybody should have every bit of the information. It's about their ability to partner with us to keep families safe and supported. And it's serious. That's why I think the process was implemented, is because it's saying, like, we're going to give you serious information, and are you going to use it for good purposes and responsibly to keep a child safe? Or are you just wanting to do this because you're curious about it?
Yeah. And I mean, coming back to the weaponized point, knowing information can be weaponized in ways that are both explicit and insidious, but also in ways that folks don't even recognize that they're weaponizing that knowledge and information. And so I think, to your point, particularly around communities that have historically and continue to be harmed by child welfare disproportionately, that there is I would say the guarantee that some folks having more access to that information would use that information detrimentally against the child and or family, whether they were doing so like consciously aware or not. I do think that there's the potential for that information to be misused. Yolanda, I see you put some. Yeah, 100%.
I was just going to say, people weaponize it just knowing that the department is involved, right?
Correct.
Just saying that what I reported to the department got assigned for assessment. Reporting parties do treat children and parents differently once they know that that the department is involved. And sometimes that's for good, and sometimes that's for negative. And so I just think we have to acknowledge that.
And I think that comes up to Dawn's point. earlier that, you know, just the allegation can be detrimental, even if it's ultimately determined to be founded or unfounded on appeal, right? Reversed on appeal. And so there can be some, you know, real significant consequences to having information, even if it's just cursory information, not having any detail, but knowing that an individual is being investigated for child abuse or neglect, you know, can have real consequences associated with it. April?
Yeah, I just love this conversation. I could talk about this stuff all day because I think that I think just the overall theme that we have had, especially from Michelle's conversation, is that we never want to do harm. We never want to do harm to a child or to a family. And I think we all recognize and the wrong information being in the wrong hands could do harm. And that's why every single case, every single family, every single situation is very different. And that's why it's very important for child welfare and caseworkers that are involved to know their families, to know their cases, and to know the situations individually so that these types of conversations can be had with who should have the information and who shouldn't, maybe, right? I mean, I know that there's rules with regards to what information can be shared and with mandated reporters, but I think that there is also, you know, that's why we stress the importance of getting to know our families that we're working with, having conversations with them, and understanding the situations that we're in. So I just wanted to throw that out there. I do think that caseworkers do a pretty good job at getting to know their families, and I would be worried if they don't, because that's, you know, we're involved and, you know, sometimes it's a very intrusive feeling to have child welfare at your door, and we acknowledge that, right? So, you know, but our goal is to never do harm, and so it's important for everybody in child welfare involved. And I will go to my grave saying this and say this to every county that I come involved with, is that you got to get to know our families, got to have conversations. We've got to be able to, you know what situations the families are in and be able to help make decisions with regards to what information is shared to prevent future harm. So
Thank you for that.
A minute. So yeah.
Yeah, no, I like soapboxes. Crystal, I'm gonna come to you in just a moment. One thing that I'm sitting with is that there is a difference in sharing back information around involvement, and, you know, substantiated allegation and further involvement by the child welfare agency. And we know that most reports are either screened out or unfounded. And so when we think about those that, you know, are screened out, in particular, and you know, so they're screened out, not meeting the, you know, sufficiency around the allegations of abuse or neglect, but the family does in fact have some needs. I'm wondering specifically, just when we think about that particular class of kids and families, whether and to what extent information sharing back around, no, this, you know, this is going to be screened out, or this has been screened out, but connecting the family with some services and supports might be of benefit. And just get folks' reaction to sort of that conceptually, and, you know, what thoughts, ideas folks have around any specific recommendations around information sharing back. Again, that child welfare is not going to be formally involved in investigating or assessing and, you know, any further services, but you know, as in a way to try to connect family to community, if there is an opportunity to make some recommendations around that. Crystal?
Well, my comment was going to be similar to yours, Doris, in that as you guys consider all of the extremely important, valid considerations around sharing incident information, as I've worked with other jurisdictions around a whole variety of concepts of how to get services to families, not in response to a founded report, but in response to a family struggle or a need. And I hope you don't, I hope that as you develop all the information for this about this explicit stuff that you can share about an incident, please also address what you can share about a family need or a struggle. There are the San Diego 211 thing, which has a relationship with the Child Welfare Agency. When they hear about someone with a housing need, they make a direct referral over to the housing community resource and just say there's a housing, consideration here to explore. It's voluntary, but they're not sharing anything about an incident, but lots of times it's spurred by a call to a hotline of some sort. So I think that there is definitely a big value in sharing some generalized information about what a family is needing and how community resources could help address that need without talking about an incident.
Thank you, Crystal. And I feel like some of the metro counties in Ohio are doing some work around that as well. And, so I appreciate you piggybacking on my question. April, did you have your hand up still because you wanted, oh, it's just still, okay. So, any thoughts around what, Crystal offered as, and the potential for sharing information that's not going into the details of the allegation, but information sharing between child welfare and other systems or agencies in service of the underlying needs of families where child abuse or neglect is not currently present. Michelle?
Again, in my preventative work in Arapahoe County, Trails holds a lot of information about families, especially, it's been in place now for, since March of 2001. So 23 years of history is inside Trails, which means we have multiple generations involved in Trails. And with families who have long involvement or a lot of involvement with the state of Colorado, what I found is oftentimes we know a lot about the trauma that families have experienced, and they certainly wouldn't want to divulge all the details about a family's drama. But one of the challenges that I faced in the preventative side of the work is helping to reporting parties to understand that how families were showing up to them was as a result of the trauma that they had experienced. And the desire to just say, if you could only understand what this family has been through, then maybe you would have more grace and patience and understanding and being willing to support a family. So, a death in the family, a child who was sexually assaulted. Not that I want to share the details of that, but I always wish that I had more capacity or ability statutorily to say, there is more to this family than what you are just seeing in your lobby or them in front of you. And if you could better understand the path or the journey that they have been on. And so I often just tried to encourage them to slow down and build a relationship with the family so that then the family might be more willing to share some of their struggles so that they could be better understood. But families aren't always equipped or willing or able to do that. And so I agree with the ability to share more details for the good of the family so that they could get the love and support that they needed from community partners. But again, I always worried about that they would turn around and use that information against them. So if, a mom had successfully overcome substance use, had gotten treatment, and was doing really well, if that information were to be shared with a community partner, that they would again use that against the family. So again, it's a both and for me of this struggle of in the right hands with the right person, information can be great and it can also be dangerous for other people.
Yeah, thank you for that, Michelle. Yolanda?
Yes, I just wanted to share just some background and context because I think it enriches this conversation. Is that when Safe Care Colorado was first a prevention type resource for families that had children 0 birth to age 5, and there wasn't really a comprehensive legal opinion about whether or not we could refer so families that had been called into child protection and were screened out, so the referral was not accepted for assessment, whether or not we could refer them to Safe Care Colorado without their consent. And so now that, that happens sort of as a whole different process. When it first was there, at least when I worked at Denver County, we were like, we're not sure about this. So we're going to gain the consent, the verbal consent of the family to refer them for a community-based resource that could be voluntary if they chose to utilize it. And so my job, part of my job was to call families. And it was really a kind of an awkward situation because they wouldn't have otherwise known a report was made about them to child protection unless the reporting party had told them, right? Because otherwise they wouldn't have gotten any contact from us. So this is very early on when prevention was just starting in the state. And of course, you can imagine that families were like, what? Who reported? And what are you talking about? And what does this mean? And so just trying to alleviate some of that concern and anxiety that my cold call to them created, and get their verbal permission to just allow me to refer them to Safe Care Colorado. I think at the time Savio had the contract for that, so that Savio could then reach out to them and offer this service that was voluntary if they wanted to utilize it, this resource. And that part of it, so why I'm sharing that as sort of background and context is to say that it felt good to be able to most of the time be successful at getting the family's consent to say, this is just an opportunity for you to learn more about a resource that could be free and offered to you if you wanted to take advantage of it, voluntarily. It is not going to, your choice is not going to impact child protection's decision to not assign this referral that we've received to a caseworker. And hopefully that was a little bit reassuring, so they didn't feel like it was a coercive arm twisting of like, well, if you don't do this, if you don't say yes, if you don't, which sometimes is what our system can feel like, right? We're going to call something voluntary until it's not, right? Because you weren't cooperative, or that perception of what compliance, cooperation, and all of those things, or how Michelle Dossi mentioned, like the weaponization of information against families. And so I think, like, answering the question, it's always been a tricky question as well with prevention when it comes to child protection, because I know there have been folks on different sides of that discussion around whether in our decision making on child protection, should we know about prevention, whether or not a family engaged, right? Because that could, so the idea of like, well, no, right now we don't know. We don't know if a family agreed to prevention services. We don't know if they engaged with, prevention. We don't know that information because we were, like, as a larger system, concerned that that would then get weaponized against a family. Oh, you were offered voluntary prevention services, you decline those. Therefore, we have more concern for you as a family, and now we're going to assign it to a caseworker to do a child protection assessment and intervention in that way. And that felt like weaponizing the system against families, where how could you call something voluntary if it could be later used as part of a decision-making matrix to say, well, you didn't choose to voluntarily participate with prevention services, therefore a possible consequence is getting a child protection assessment on your family later down the road. So that's always been a conversation, not only the confidentiality piece of referring families on to other entities that the family doesn't know or didn't consent to that referral, as well as what engagement with those other services, how that could then come back and hopefully not yet had the potential to be used against the family if there was the perception that they did not engage in that offering of services. And so I always think about that too, just with prevention overall. And when callers are calling because they really want services for the family, which is so important, would there be is the unintended consequence of that the judgment that gets passed from the reporting party, from the child welfare system, from whomever, if the family doesn't engage in those services that many of us might feel like would benefit them? That's always a worry of mine too.
There is a big part of me that feels like anytime child welfare is coming back to the family and saying that, oh, we're not going to formally be involved, but we recommend that you engage in these services, that's automatically coercive because they have the power to take your kids away. And so even if the intent of the conversation is not to be coercive, there is an element of power differential that makes that, in my mind, coercive 100% of the time. But I want to come back to sort of connecting this conversation to another recommendation that has already come out of the task force. And I know that you're going to see the full set of recommendations together. And so it may not be top of mind. It certainly wasn't for me. But that there is this recommendation that will be included around standing up a warm line similar to the 211 that in San Diego that Crystal mentioned. And I'm wondering if there might be an opportunity to include in recommendations there are two thoughts that I have. One, just sharing with the mandatory reporter that based on what you're saying to me, I think this report is going to be screened out, or I'm recommending as the worker taking the report that this report gets screened out. But I hear you around your concerns for this child and this family. And so I'm going to connect you then to this warm line. So a mechanism for sharing out, sort of what is going to be the recommended disposition of the hotline report. If that disposition is to screen out, and then also providing back to the mandatory reporter, either in real time or at a later time, once, if the supervisor has to review the report before it's ultimately finalized, to say that, yeah, this is going to be screened out, but I think there's an opportunity to, for you to engage with the family around connecting to 211, if there is such a relationship already between that mandatory reporter and the family, where they could have that dialogue. I mean, we've talked about in previous conversations, there being an opportunity for there to be more dialogue with mandatory reporters, especially those who have an actual relationship with the child and the child's family. But I wonder if I want to come back to this potential for sharing back information around the disposition of a hotline report. And specifically, if there is an opportunity to connect the family to community-based services and supports through the mandatory reporter. So giving that information back to mandatory reporters as another option for, trying to connect the family to services. Any thoughts, reflections on that overarching kind of idea?
I just put a suggested.
I wasn't tracking.
I just put a suggested one in there of what you could say. I do think I might have some disagreement from fellow counties or the state about this, but I do think we have an obligation for to notify reporting parties that they shall receive information from us about the disposition of the referral, whether that's the steps that'll be taken if it's not accepted for assessment, like referred to prevention services, like you said, or if it is assigned, who's the assigned caseworker and their contact information. That the responsibility falls on the department, which is not a favorite thing for me, but I do think that a reporting party should be entitled to know what happens to the referral that they make.
And that's all reporting parties or just mandatory reporters?
I personally think it should be all reporting parties, but I know we're specifically here to talk about mandated reporters.
Don, I see you nodding. What do other folks feel about that?
I would personally agree with that. I think because even with the specified mandatory reporter information, it really was your report accepted for further assessment or not? And if it was, who's the caseworker assigned? And then did it result in services offered to the family, something like that. So it's limited information. It's not all like what happened in the assessment, even what the finding was. None of that is reported out, and even to specified mandatory reporters. So I think with that baseline of information, and I do know some counties practices, like whether you're a mandated reporter or not, if you call back and say, I made a report on Monday, I'd like to know what happened to my report. I'm a concerned family member and I did make the report. I did share my name at the time. Then some counties will confirm whether it was assigned to a caseworker or not. And then that's it. Because I think that's often what people want to know. Like, what did you do with my report? AKA, is it going to be in their maybe mindset investigated or not, or looked into further or not? And so being able to provide that, because otherwise, right, to Michelle Dossie's point, is like the onus on the reporting party and the county. Like, I don't know if you saw what I put in chat. It was the language from the Code of Colorado Regulations, Volume 7, that if the county is not sure if the person's a specified mandatory reporter, the process that then has to go through to vet that information, and the reporting party may not have time for that. The county may also feel a burden, to do that extra lift. And so this idea of like, well, couldn't this just be information that every reporting party, or some version of this, that every reporting party has the right to just know if their report was assigned to a caseworker or not?
I do know from doing the mandatory reporter training in Arapahoe for years that people just want to also know what happens after. So, okay, it got assigned to a caseworker. So now what? What does
that mean? Yeah.
And so a lot of the training that I did was really more focused on, okay, what's the difference between a family assessment response and a high risk assessment? How long does a caseworker have to do the investigation? What are the types of findings? What's a response time? What, all of the things, so that they better understood what was going to happen, so that they could then help support the family as they were working through our system, of, what they could expect to have happen.
Yeah, I could see that being a common question, because it feels like a black hole. You make the report and then you don't hear anything else. So you're not sure what actually is happening. Anyone have concerns about taking the approach that Michelle put in the chat and also voiced over around, providing some minimal information back to anyone who makes a referral that includes ultimately what happened to that referral, what happens next in the process, and potentially, if it was assigned to a caseworker, who that caseworker is and how to get in touch with them. Anyone have concerns about that? I don't see anyone hurrying to come off mute. So question, is there currently, for those who are entitled to follow-up information, and maybe this is a JP question for you. So it sounds like in Trails, there is the sort of template that can be used to follow up. Is that the place where there might be an opportunity to have this kind of standardized follow-up for every referral that's made?
Yeah, I think so. The way that we generally approach anything as it relates to Trails is, we have program staff or county staff or whoever it is requests new functionality or new changes in processes, and then the Trails team figures out how to make that happen. So if there's a requested change to either new fields or different fields or different processes, we just need to kind of meet with whoever is appropriate to convey what we want to have happen going forward. And then my team figures out how to document that and make that happen. Did that make sense?
It did, thank you.
Yolanda and JP, correct me if I'm wrong, Trails already has the ability to kick out a letter with a disposition. Counties are not big fans of how it's structured because it is not, I don't know that it's the best format, but it does already exist that you can generate a letter to the reporting party.
Yes, so in the hotline record, there's a reporter type, and then certain types are mandatory, classified as mandatory reporters. So then in the referral, there's this tab called mandatory reporter, where you answer you confirm whether the person is a mandatory reporter or not. And then also whether they're a specified mandatory reporter, and then if they have a ongoing role in the child's safety. So it'll come across as mandatory reporter, yes, based on what you said as the reporter type. Then the person goes in and says specified mandatory reporter, yes or no. And then they toggle ongoing role in child safety, yes or no. And so if they're answering yes to specified and yes to ongoing role in the child's safety, then a template letter will be generated. And if there was an email address or something that was entered on the reporting party's type, it can be sent to them by mail, it can be sent to them by email. It could even be a phone call. They wanted a phone call back and let them know the disposition of the referral. So there is some it's a combination of the systems prompts with the persons going in and confirming, yes, we believe this is a specified mandatory reporter with a role in the child safety.
And so in this instance, there would be a recommendation around a letter that gets generated for all reporters that includes that like basic information. So, you know, not necessarily changing what exists today with respect to specified reporters, but having a template that for all reporters can get generated that includes that basic information.
I think the other thing to know, you know, there's a part of the statute that says that, you know, all mandated reporters shall make an oral report immediately upon becoming aware or suspecting abuse or neglect and follow it up with a written report. And I know in Arapahoe, you know, our reporting parties, we train to that. They follow up typically with a written report. And that's how Arapahoe then notifies them, is that once they send in the written report, we then will dispo that written report to let them know what the disposition of the referral is. And so there's some other ability within the current statute, I think, to clean that up a little bit. I don't think a lot of reporting parties know that or are trained to that they're not only obligated to make an oral report, they're then obligated by law to follow up with a written report. And when that written report is submitted, there is, you know, there is some capacity, excluding what's already existing in trails, for there to be then communication back to a reporting party about the disposition of the referral in writing. Does that make sense, Doris, what I just said? Sorry.
It does. And I feel like how many reporters are following up with a written report?
Very few. I will tell you.
Yeah, I was thinking it's almost
our,
zero.
Yeah,
What
mostly
percent?
it's our school districts, because they are, you know, they really want to make sure that they adhere to the law.
Yeah, so I feel like, you know, not specifically related to this conversation around information sharing, I do think that that Brian may be making a note around that specific language. Like if nobody's adhering to that language should be stricken. And I think that, you know, based on the conversation that we've had previously around, you know, just the burden of making a report, having someone make a call and make a report and then follow it up with a letter, that just seems like a crazy burden. And so, you know, I feel like somewhere included in the recommendations, there should be some language about striking that, following it up with a written report piece.
I think that is a perfect demonstration of intent versus impact, right? And what is good in theory versus what is practical in practice. That disconnect between policy and practice. That's a perfect example. That needs to go.
100%. 100%. And then Donna, since you're off mute, you put something in the chat. I'd love to have you voice over about this sort of us versus them.
So many things in the chat.
Okay.
Which
piece,
Doris?
Girl. Okay, so the last thing that I saw, you were talking about the collaboration piece, but because of sort of like this us versus them mentality.
Right. I think that plays out, right? I feel like mandated reporters that are not, you know, that are sort of outside of the system, but feeder into the system, when they don't know what's going on, they tend to, you know what we do. We make up a story in our head. It's never with positive intent. And then it becomes this us versus them scenario, right? And I think some of the collaboration and resentment that I think happens across sectors could be eliminated just by improving that communication piece about what's going to happen, like, or what happened to that report that I filed. But when people sort of, you know, sit in silence, or they, you know, they don't know, they just sort of make up that story. And again, it's never that positive intent piece.
100%. Thank you. So I put in the chat, just as we prepare to wrap up the conversation. I think having us all like in this, you know, conversation together has been really helpful. But for those of you who like to see a prompt and maybe think on it, and, you know, feel free to use the chat. Just want to capture any additional recommendations any of you have around improving inter and intra-agency communication, confirming receipt, and sharing the outcome of reports on children and families that are reported to hotline, taking the language directly from the directive.
I still think that there needs to be some improvement between cross-reporting between law enforcement and human services. I think this continues to be a challenge for our system that, we'll find out that law enforcement got the information first and they won't report it to the department or vice versa. And what information is shared and when I think it was Dawn mentioned, the challenge or the messiness when law enforcement and human services or human services shows up to do an investigation. It's very messy. It's very clunky. I don't have all the answers for it, but to me, it's been a long-standing problem for the child welfare system about those pieces of when to report to law, because the statute actually says that counties are required to share all of our reports with law enforcement and the DA. And that's something that in Arapahoe, we've really had struggled with because of the magnitude of the referrals. Our law enforcement agencies weren't prepared or able to handle the 30,000 calls we get every year. So to me, that's a recommendation. That's a whole nother meeting's worth of conversation I could have.
Yeah. Well, and it sounds like the statute requires information sharing one way, but doesn't make the same requirement going the other way. So when law enforcement is, has an investigation around allegations of abuse or neglect, the sharing back to human services doesn't happen.
Well, they're mandated reporters, so they're required to report to us, but what they share it depends on the jurisdiction. Somehow,
Gotcha. Okay.
Some have good relationships, some don't, but
yeah. And in the places where they have MOUs, they already have a relationship that sort of facilitated the development of an MOU. And so it's really, I think, likely those places where they don't have that kind of relationship. Yolanda, I see you raised your hand. Brian, you still have your hand up. I think you were just
I'm
sort
sorry,
of nodding.
Brian.
I'd like to have a question.
Oh, perfect.
Yeah. So just, I know some people spoke quite strongly about striking the written report requirement from statute, but I just wanted to give an opportunity for if anyone wants to speak in defense of it, or just to make sure that I'm accurately capturing the sentiment of the whole task force. Just wanted to ask that question.
The sentiment around why it should be stricken, or are you trying to get the counter
If
argument?
it should be stricken. There were just a couple people who said that it should be stricken, but I wanted to basically do like a pulse check to see if
I know
the majority
Donna
of folks
shared.
agree with it or.
Okay. Donna shared like one of the challenges in having that language is that, and Michelle shared this as well, is that it is not adhered to. And so having this disconnect between actual practice and the language of the law is a problem. And so having the law then reflect what people are actually doing in practice.
No, yeah, I understand. I just wanted to see if anybody on the task force disagrees with that.
Oh, gotcha. Okay, sorry. All right, seeing no thumbs up, no hands up, no one coming off mute. So your silence is going to be taken as agreement. Got what you need, Brian?
Yeah, thanks.
Awesome, thank you. Yolanda?
Yes, I just wanted to share a conversation I had earlier this week, or got to listen in on earlier this week, is that there is a Reimagining Child Welfare Committee task group that's meeting, and they've also been discussing ways, also concerned that only about half of our 200,000 plus calls a year result in a referral, and then less than a third of those end up with as an assessment. That same kind of conundrum, and trying to be able to redirect people to resource information, which is often what folks need, that are then calling the child abuse reporting hotline, and trying to see whether there's the availability as well as the interest in not only just the warm line that you talked about, Doris, and we've talked about before in this task force, even at the time of the hotline call, like the pre-recorded message, being able to indicate that this line is for reporting suspected or known child abuse or neglect, which, like a less than a minute kind of introduction to what that actually means. And that if somebody is interested in learning more about potential resources available to the family when it's not abuse or neglect, kind of a push one for X, resource over here, like hand off to this whatever type of maybe additional phone bank of resource information there could be. So I just want to let folks know that that's also a conversation. And I think there was intention from the leadership of that group to talk with you all, Doris, and Stephanie and folks over here, because we're also simultaneously working on recommendations that maybe it can be a combination of recommendations around how to defer calls from the point of hotline, even through a pre-recorded message, to connect them to other resource opportunities, and then potentially also have that warm line where somebody could speak to them about the opportunity to refer to other resources as well, if that was of interest. So I just wanted to share that. I learned earlier this week about the Reimagining Child Welfare Committee group that is looking at what would the technical and logistical part of doing an introductory message on the child abuse reporting hotline system be, and then where could those calls divert to, that if somebody wanted to push one for a different type of response.
I think that's a great idea, but that assumes that people know the distinction between abuse and neglect. And if you don't know that, you're not going to know, right? You're going to assume that it is child abuse and neglect, and you're still going to get reports that are neglect based, right? So a pre-recorded message is only good if you're defining the distinction between those two things before the caller pushes a button.
Yeah, that Donna, that was my understanding. They had like a minute introduction message that, of course, it's not going to be perfect. It was at least trying to clarify this line is for reporting child abuse and neglect, examples of which include ... So not perfect. However, trying to at least give some frame of reference, and if that doesn't seem to be why you're calling, if it's really about resources for the family, could you push, you can also push one to be directed to XXX, right? Like that. So just one means of just trying to reduce the funnel that comes into child protection from families that really shouldn't be reported to a child abuse reporting hotline. So just something they're working on. I want to let folks know about it.
And I think connecting that conversation back to the letter that we talked about earlier and having a recommendation around a follow-up notification that goes to all reporters, it could also include other resources for the family might include these things. So not trying to make it a 10-page letter, but if there is a way of to Crystal's point in the message in the chat, that you have these multiple mechanisms of trying to provide information and other connection points for families to get connected to services and supports when the issue that has been reported does not meet the standard for child abuse and neglect. So that could also be included again in that follow-up letter that we talked about a moment ago. Any other recommendations that are top of mind for folks as you think about information sharing and the like? Crystal, I see you nodding vigorously. Are you reading the chat?
Yes, I was just nodding to Yolanda's comment.
Yeah, agreed 100%. Any other thoughts, ideas, recommendations before we go back to the big group? Or we're not going back, we're staying put. They're joining us. Yay! As my boxes move around.
Just want to say thank you again to April, Jessica, and JP for joining us. It's been really helpful.
Jessica, I love it when and you and Yolanda, I love it when people use their reactions. It makes my day. All right, thank you all. I think this has been a very rich conversation. And I know that it's hard to sort of keep each of the sort of the particular part of the directive that we're talking about really focused, because a lot of these topics do bleed into one another. And so I appreciate the discussion and also just the connectedness of around other recommendations that we've made and other discussions that we've had. So I know that the other group is supposed to be joining us any moment now. If anyone has any last thoughts before they intrude upon our space, please feel free to come off mute and share out, or use your very many icons to do so. And if not, we'll just sit tight until the other group joins us.
So I
Crystal?
just wanted to share that the conversation about the specified mandated reporter was really interesting to me, and I learned a lot because that's a concept I haven't heard about in other jurisdictions. I mean, you know, I always hear about the whole bowl of mandated reporters and certain policies around them, but to discuss the policies related to a relationship to a child and the caseworker making that decision, that was a really interesting discussion.
Same. And that element that helps to define them as a specified mandatory reporter with that ongoing relationship also lends itself to, you know, having conversations about other options for to meet the family's underlying needs when what they're reporting does not actually constitute child abuse and neglect. And so I think it having that kind of designation I think lends itself to some of the other conversation that we've had about potential other ways of engaging the mandatory reporter to get the family connected to services and supports within the community and outside of the child welfare system.
I also think about one of April's early comments when she was saying sharing, both receiving and sharing reciprocal information, which leads to that dialogue thought. And so I don't know, I just think that's where the sweet spot is for families.
Agreed. And then since you mentioned the April, you know, I would be really curious to see what that MOU looked like or looks like with public health. You know, because I think, again, as we think about ways of connecting families to services and supports, even when a report is made to child welfare, you know, sort of just curious about, you know, how that happens and if that might be a template or model that could be deployed in other jurisdictions. Michelle, I see you came off mute.
I would tell you the public, you know, public health nursing goes hand in hand often with child welfare. It's actually a well-known model that I think has demonstrated good outcomes. And lots of counties use public health nurses as a part of their assessment or treatment and services, and in preventative ways as well, to go on and provide services to family through like nurse support programs, things like that. And so I think there's a lot of different contracts that you could look at that show how that information is shared.
Yeah, thank you, Michelle. I know Nurse Family Partners
water
is.
Yeah, there's a pitcher of water.
Oh, here they come.
We're back. We're here. Sorry about
Okay.
that.
No problem.
We had to finish up with a quick poll. All right, y'all. We have 4 minutes left, and we'll be back next week. So we've got a lot of work to do between now and then. Just want to name. Might take us a little bit to get materials together. So just heads up that you might get a little bit later than typical. Just based on the work that needs to be done between now and next week. If there are members of the public that would like to give public comment, can you send me a note in the chat? I have not received anything so far. You can also come off mute. We do have a few minutes and would love to hear from you if there's anything you'd like to add. All right, seeing no request for public comment again for members of the public, really appreciate you being on the call. You are certainly always welcome to join us. We have been breaking up into subcommittee groups, and so there's always a link to join either of the groups. You can also review the recordings on the CPO website for previous meetings and view all of our minute materials. So just appreciate your participation and engagement on this critical topic. So thanks for being here. With that, I'll hand it over to Stephanie to close us out, and then we'll see y'all next week.
Yeah, just thanks everybody for your time and and your thoughtfulness, and look forward to seeing you soon. Thanks.
Great. All right. Thanks, everyone. Have a great rest of your Wednesday. I'm no longer host, but does someone want to stop the recording? And I'm guessing Sam had to step away, so also you might want to remove as participant for.
I think that's me. I'll stop the recording now.
Okay.